Welcome back to The Explainer. Today, we're diving into an incredibly urgent and honestly unprecedented situation that's unfolding right now in the immigration and investment world. For decades, this specific legal pathway has been a beacon for folks looking to build a life in the United States. But in 2026, that stable pathway has been completely upended. We're talking about a sudden, massive wave of EB-5 visa revocations. If you, or maybe someone you know, is holding or pursuing this visa, the landscape has literally changed overnight. Understanding these shifts isn't just a good idea anymore. It's absolutely critical. $1,050,000. I want to start by throwing this massive figure out there to instantly ground us in the incredibly high financial stakes required to even get your foot in the door of this program. For the people involved, this isn't just some casual business transaction. It's not a temporary student visa. Staking over $1 million means this is a life plan. It's an entire family's future on the line. And that is exactly why this current wave of visa revocations is sending such massive shockwaves through the whole immigrant investor community. To make sense of this complex crisis, here's our roadmap for today. First, we'll cover what the EB-5 actually is. Then, the 2026 revocation landscape, the specific risks and vulnerabilities, immigration status versus investment, the path to citizenship, and finally, exactly what investors must do to protect themselves. All right, let's kick things off with part one. What is the EB-5? Just the basics. So let's dive into this. Congress actually set up the EB-5 visa program way back in 1990 with a very specific goal in mind: give the U.S. economy a boost through job creation and foreign capital. To qualify, an applicant has to put down that standard minimum of $1,050,000 into a new commercial enterprise. Or there's an alternative. They can invest a reduced amount of $800,000, but only if those funds go to a targeted employment area. So think rural regions or places dealing with really high unemployment. Now, in exchange for these massive capital injections, the U.S. offers a highly coveted reward: lawful permanent residency for the investor and their immediate family. It's basically a direct trade, right? Economic stimulation in exchange for long-term residency and eventually a path to citizenship. But here's the catch. That long-term promise is under immense pressure right now. Let's move to part two, 2026 revocations, the landscape. Under the current administration's renewed hardline stance on immigration, the legal environment has shifted aggressively. The engine behind this? A dramatic expansion in the use of visa revocation authority under Sections 221G and 237 of the Immigration and Nationality Act. Now, to be fair, visa revocations are not some brand new concept in immigration law, but the sheer scale and the speed at which they're being executed in 2026 is entirely unprecedented. It's shaking confidence across every single visa category, but it is especially alarming for investors who really thought they were standing on perfectly safe ground. So you're probably wondering, what exactly is triggering all these revocations? Well, it's not just major crimes. Look at these points. Prior arrests, even if there was no conviction, are acting as massive red flags. DHS screening algorithms are actively combing through and flagging social media activity. Any alleged ties to hostile foreign governments or organizations are being heavily scrutinized. They're also zeroing in on procedural or minor documentation irregularities that pop up during enhanced revetting. And finally, public benefits usage, even if it's just by an applicant's family member, can trigger a revocation. This revetting process is incredibly thorough, and it's catching even previously approved investors. So where does that leave EB-5 investors specifically? Let's get into part three, risks and vulnerabilities, and see where the danger lies. Now, while EB-5 investors do occupy a somewhat protected position compared to folks on temporary visas, they are definitely not immune. There are three very specific dangers targeting investors in 2026. First up, source of fund scrutiny. USCIS is heavily auditing petitions, especially from places like China, India, South Korea, and the Middle East. If there's any opacity at all in where your money came from, that can trigger a revocation. Second, regional center failures. Hundreds of investors are stuck in total legal limbo right now because non-compliant regional centers are being shut down, and that puts the investor's petition at risk regardless of personal conduct. And third, policy-driven denials. The administration is applying much stricter interpretations of what constitutes at-risk capital and job creation metrics, meaning projects that previously qualified are now failing under these new internal guidelines. It's kind of like the goalposts keep moving. Which brings us to perhaps the most critical, myth-busting concept in this entire explainer. Part 4, status versus investment, a critical divide. Okay, the crucial takeaway here is this. Confusing your immigration outcome with your financial investment can be incredibly costly. Look at this side-by-side comparison. On side A, you have your immigration outcome. Maybe your visa gets revoked or your petition is denied. Naturally, you'd probably think, well, the deal is off, I'm getting my money back. But look at side B, the financial reality. A visa revocation does not automatically trigger a refund. In most cases, your $1 million stays locked in the project entirely regardless of what happens to your green card. They are two completely separate matters. If an investor does face a revocation, they're essentially thrown into a chaotic legal maze. They might try to appeal the decision in federal court. They might attempt to pull their money out by triggering really specific exit clauses in their investment contracts. Or they might even have to hunt down an entirely new investment project just to stay afloat. Navigating this crazy web of immigration and contract law by yourself is virtually impossible. Having immediate expert legal counsel is absolutely essential here. So how does all this turbulence impact the broader timeline? Let's look at Part 5, the path to citizenship. Is it still viable? Historically, this whole process was expected to be a pretty stable journey. An investor gets their approval, secures a 2-year conditional green card, files to remove conditions, achieves permanent residency, and then, after 5 years, they naturalize. Boom, done. But in the current climate of 2026, this clean timeline is a complete mess. I-829 denials have risen sharply. We're seeing investors who have waited years, created the required jobs, did everything right, and they're seeing their condition removal denied on minor technical grounds. Even folks who are deep into the naturalization process are facing unexpected complications from the re-vetting of their original visa applications. I actually want to pause here for a second because there's a quote from our source material that really hits the nail on the head regarding this systemic risk. Even approved investors with valid green cards can face deportation proceedings if their underlying visa petition is found to have any deficiency. This is the chilling reality we're dealing with. Past approval simply no longer guarantees future safety. Under the current administration's strict revetting process, real or even just perceived deficiencies from years ago can suddenly unravel your entire life in the U.S. All right, so knowing all of this anxiety-inducing information, how do we fight back? Part 6, what investors must do, immediate action steps. Sitting back and just hoping for the best is not a strategy. You have to be proactive. So here is your concrete checklist. Step 1, work with an attorney to audit your petition documents immediately. You want to find those red flags way before USCIS does. Step 2, verify your regional center status. Make sure they are in good standing on the USCIS public list because, honestly, your petition is only as secure as they are. Step 3, document your source of funds exhaustively. Gather tax records, bank statements, property sales, literally everything. Tracing your capital clearly is your absolute best defense against an audit. And step 4, read the fine print of your investment agreement. You need to know your exit options for your capital before a crisis even occurs. It's really important to understand the broader context driving your need for action here. The administration has positioned aggressive visa enforcement as a massive centerpiece of its agenda. We've seen executive orders from 2025 and 2026 expand DHS authority with very limited judicial review. They've severely reduced the notice period you get before action is taken and heavily increased intelligence sharing with USCIS. Now, immigration advocacy groups have fought back, and yes, there are some temporary federal injunctions in place. However, the legal situation is incredibly fluid right now. You simply cannot count on court intervention as a reliable safety net. Look, the EB-5 program remains an incredibly powerful pathway, but it now demands way more diligence, flawless documentation, and expert legal backing than ever before. This isn't just a threat for a few bad actors anymore. It's a systemic risk affecting good faith investors who literally did everything right. So I want to leave you with this final vital question. Is your EB-5 petition truly secure? Please don't assume you're safe just because you were approved in the past. Take the information from this explainer, review your legal and financial standing today, and ensure your American dream remains protected. Thanks for joining me, and we'll see you next time.